the League of Women Voters and DuPage NAACP Forum for the Illinois Appellate District 2 Judicial Candidates. My name is Patty Lackman, and I am the Voter Service Chair for the League of Women Voters of Central Kane County. The leagues participating in the forum are the Leagues of Women Voters of the Aurora area, Central Kane County, DeKalb County, Elgin area, and McHenry County. This forum was originally scheduled to include the candidates for District 2 of the Illinois Supreme Court. Due to a scheduling conflict, one of the candidates was unable to attend. The League of Women Voters has an empty chair policy, which prohibits a forum with only one candidate for a position participating. As such, we are attempting to reschedule that forum for October 4th at the Geneva Library. Invitees to that forum include candidates for Illinois House 65 and the 11th Congressional District. Invitations have been sent to the candidates for those offices. The candidates participating in today's forum have signed and agreed to the format and media policy required by the League of Women Voters. Today's forum is being live streamed and filmed by Audrey Kapp from our local cable access television station, BATV. The tape will be posted on the websites of the local leagues participating, the DuPage NAACP and the Illinois Voter Guide. As I indicated, we are co-hosting with the DuPage NAACP, and the representative that was to be here to give some welcoming words was unable to attend. The moderator for today's forum is Jan Dorner, President and Voter Service Chair from the Elmhurst League of Women Voters. Jan?
Welcome to the Judicial Candidate Forum for the Second Appellate Court, hosted by the League of Women Voters and the DuPage chapter of the NAACP. My name is Jan Dorner. I'm from the Elmhurst League of Women Voters. The League of Women Voters is a nonpartisan organization that neither supports nor opposes candidates or parties for any office. The League's purpose is to promote political responsibility through the informed and active participation of citizens in government. Providing this forum allows citizens to become better informed about the issues facing their community and to become better acquainted with the candidates running for office. We're happy to provide this service for the community. The League of Women Voters is not responsible for verifying the accuracy of the statements that candidates make in this forum. At this time, I would ask that you please turn off cell phones and other electronic devices. I would also ask that you refrain from applauding or in other ways demonstrating support or opposition of a candidate. No campaign literature may be passed out in this room. Remember that everyone is here to learn more about the candidates and are not interested in your statements. No cards and pencils have been provided on which to submit your questions. Questions will be screened for duplication, clarity, and appropriateness to the office being discussed. Please signal a volunteer when your question is ready for submission. Also signal a volunteer if additional note cards are needed. Note that these candidates will not be able to answer questions concerning how they may rule in a specific case, and you should focus your questions on the candidate's knowledge, character, or effectiveness. The candidates agree in the ground rules that no voice, image, or other duplication of the forum may be used by any candidate's representative or campaign in any campaign advertising. They will each present a 2-minute introductory statement. The order determined alphabetical by last name, and then questions will be asked, and each candidate will have 90 seconds to respond in alternating order. Closing statements in reverse order of the introductory statements will be 90 seconds. Candidates, please notice the timers. When you see the stop sign, you may finish your sentence. Our candidates today are Susan Clancy Bowles and Chris Kennedy. So let's start with Susan Clancy Bowles. With your introductory statement, you have 2 minutes.
Okay, thank you very much. I appreciate everyone being here today. My name is Susan Clancy Bowles, and I am born and raised here in Kane County. I like to tell people that with me, you get 3 for 1. you get my experience. I am the only circuit court judge in this race, which means that I have been previously elected by the voters. I have been on the bench for 16 years, and during that time I have sat in virtually every courtroom and have presided over virtually every type of law. And while that is important in this race, is because the appellate court is the reviewing court for every trial court decision that is made by the trial court judge. So it's extremely important that you have a judge that has served in that capacity. My 17-plus years of experience as an attorney was wonderful experience to become a judge, an associate judge 16 years ago, but it's not the appropriate experience or adequate to serve on the appellate court level. I also have leadership. I'm the immediate past chief judge of Kane County, elected for the maximum term by my fellow colleagues. I currently am the civil division, head of the civil division, and run the old Geneva courthouse. I was appointed as one of only 15 judges across the state by the Illinois Supreme Court to serve on the committee to draft the strategic plan for the Illinois judicial branch. And I serve on numerous committees and boards, both by election and by appointment of the Supreme Court. I am the co-creator. Again, my leadership is unmatched in this race, as is my experience. If I were elected to this position, I would be the first woman to serve on the 2nd District Appellate Court, let alone the first woman elected to that position. So thank you all for being here and your interest in the judicial races.
Thank you. Chris Kennedy, your opening statement, 2 minutes.
Thank you very much. Thank you for having me. I'm Judge Chris Kennedy. I'm from Lake County. I am a Kennedy, but not a member of the more famous family. My grandparents were immigrants from Ireland. My father drove a garbage truck for a living. And I was able to go to law school because I received a scholarship. And I excelled in law school. I made the law review, was on the executive board. I published an award-winning scholarly article on the amendment process of the U.S. Constitution. I then became a prosecutor in Lake County and tried felony cases, violent felonies before juries and judges. I then went to a firm in Chicago and tried multi-million-dollar civil cases before juries and judges in various jurisdictions, and I began doing appellate work at that time. I formed my own firm after several years and continued that work, including appellate work. And I began taking on volunteer work on behalf of children and families with disabilities. Over the years, writing and passing over a dozen laws to help with their needs. Later on, I ran an insurance company, 2 insurance companies, in receivership as the receiver responsible for over $1 billion in assets, settlement of cases, and distributions. At the same time, I served 12 years on my local school board. I then became a judge, and I am currently assigned to the criminal division in Lake County. I hear traffic, DUI, misdemeanor, domestic violence, and bond court cases. I'm proud to have received the highest ratings from all the bar associations and to have the endorsement of reproductive rights organizations, major police organizations, as well as the working families of labor, including firefighters, teachers, and the trades who recognize my unique background and perspective.
Thank you. What contributions have you made to community programs where you live? As an appellate court justice, will you continue being involved in these programs, or will you need to modify or curtail your involvement? And that question goes to Chris Kennedy to be the first responder.
So I just went over some of my community contributions. So when you talk about leadership, to me it's about creating an organization or whatever is needed to solve a specific problem. And when I was at my own firm, we had insurance, but it was allowed to exclude various coverages for my daughter with disabilities, and I discovered thousands of other families faced the same thing, in addition to many, many other problems. And so I developed a statewide organization that I led for many years and passed many different laws some of which provide services for tens of thousands of families in need. Now, that work remains undone. The state system still requires a lot of improvement across the board, and that is something that as a judge I cannot be involved in as an advocate. Similarly, I was on the school board for 12 years, and if anybody has any interest whatsoever in local government, or you have any fears about the commitment of dedicated volunteers and public servants, I would recommend you attend some school board meetings and listen, and possibly even run yourself, because it is a democracy that requires participation if we're to keep it. So those are my main contributions, and as a judge, we are very limited in what we can do. We can educate people about the court system and about the law, but we can't be advocates for a specific cause.
Thank you. Susan Clancy Boyes, same question.
Thank you. I think my community involvement has been one of the things that I'm most proud of. Since my time on the bench, literally the 16 years from day one, I have been in the classroom, both at the high school level and at the middle school level, talking to kids about the potential criminal repercussions associated with just one bad decision. I am the proud co-creator of a program with one of my colleagues that is designed toward middle school students. It's called Worries of the World Wide Web. It deals with cyberbullying, electronic harassment, and sexting. And it is one of only 4 programs that has been adopted by the Illinois State Judges Association to be given to in schools around the entire state. We have trained judges to give this program in their own community. It's been given over 300 times. If any of you have children or grandchildren in this area, they've heard this program. We're going to Redling on Tuesday. We're going to Kendall County the following week. We end up giving it literally probably 8 or 9 times in a year. So extremely proud of that. I'm on numerous boards as well as committees, both by election and by appointment of the Illinois Supreme Court. Giving back is one of the things from day one that I wanted to do as part of my role in the judiciary.
Thank you. Candidate Clancy Bowles, you will be first to respond to this one. How would you maintain impartiality when deciding a case or issue involving decision that you personally do not support?
Well, that goes back to day one when you take an oath to sit on the bench. And that's why this process is difficult, I think, for judges, because this should be a nonpartisan race. If I'm doing my job, politics and my personal beliefs have no basis in any of my rulings. I'm bound by precedent, I'm bound by statute, and that's doing my job. So when I put on that robe, it's all about what is presented to me in court by way of evidence. So my personal opinions have to be put to the side.
Thank you. Candidate Kennedy, same question.
I can't remember which Supreme Court justice said that if you're not making decisions that you personally disagree with or have difficulty with, you're not doing your job right. And there will certainly be matters in which the law may not be what you prefer it to be, but as appellate court justices, as trial court judges, we have to follow the law. Now, that being said, there are decisions that are made within the law. There is case law that judges decide on, interpreting statutes and their applicability and things like that. But nonetheless, it's not according to our preference, it's according to what the law says. And so it is irrelevant whether I may have a personal preference for which way a law ought to be. That we are bound by our oaths to uphold the law and fulfill it according to the Constitution.
Thank you. Candidate Kennedy, you're first. What is your judicial philosophy on balancing the scales of justice, weighing fairness, empathy, and a strict interpretation of the law?
Well, that's what I do every day. I deal with a lot of pro se litigants, and access to justice is a very important part of what we do as judges, is ensure that people with fewer resources and fewer or lower levels of information are still given fair treatment. And it is what we are bound to do in every single case. And there may be great disparities in the resources between the parties, Nonetheless, we have to consider the facts of each case and do that fairly. And empathy, versus sympathy. Sympathy is absolutely not something that ever ought to come in. Empathy, I would define as really understanding people's different perspectives and where they're coming from. As a trial court judge, you're making credibility determinations based on what people say and present before you. And you have to do that with some awareness of where they're coming from, cultural differences, things like that. But that doesn't mean that we can ignore those facts and rule in favor of somebody because we like them more. You still have to apply the law equally and fairly while ensuring that everybody has an equal hearing, regardless of their resources.
Thank you. Candidate Clancy Bowles.
I think the second somebody walks into a courtroom, they deserve civil respect, decorum, they deserve to be heard. And that's all what anybody wants. I've been in juvenile division, I've sat at the state mental health hospital, I've sat in felony for a number of years, I've been in civil for a number of years, I've been in probate. You are empathetic. You need to be empathetic. You need to hear people's stories, and you need to then go ahead and apply the law as written so everybody is treated fairly. And people need to have an understanding of what's happening in court. When I issue a ruling, I want to make sure they understand it. They might not like it, but if they understand the basis, how I got there, and why the law has led me to that particular decision, then fairness, they see the fairness, and that breeds integrity, and that breeds faith in the system, and that's what we need to continue to create. So I think all three things, fairness, empathy, strict interpretation of the law, is really important because that's how you develop integrity and faith in the system.
Thank you. Candidate Clancy Bowles. What changes in the law, such as the SAFETY Act, passed last year, do you expect to have the greatest impact on court procedures and decisions?
Well, the SAFETY Act is going to be different for all of us. I mean, it's going to be a growing trend for all of us. It's going to be a learning trend. One thing with the SAFETY Act that I think we're all going to have to deal with is the fact that it's an unfunded mandate. So there's many things that we need to do, and we've started to do within our system to get ready for the SAFETY Act. But as far as having an extra courtroom, we need an extra courtroom, which then means that you need extra state's attorneys, you need extra public defenders, you need court reporters, you need interpreters, you need an extra judge. So we're already running into issues of, we have this legislative bill that's been passed and it's a mandate, but it has not been funded. So we all collectively around the state have to try and figure out how we're going to accomplish that. It's easier in some locations than it is in others, as you can imagine. Downstate, more difficult. So that's going to be one factor. Same with the fact that if no cash bail, counties got a lot of their money that went into the general fund from the fees associated with bail. So again, we're going to have to collectively come together and figure out how are we going to now adjust the legal system to deal with this act. So I think it's going to be evolving, and I think what it as written now, it won't be the same probably a year from now because we need to put it in practice.
Thank you. Candidate Kennedy, your response?
I would say this, a lot of what is being put out there about the Act is more or less, and I find sometimes much less supported in the facts. The basic rework of the bond system is to eliminate money as a determinant of whether or not you're released. And it does track the federal system that's been in place for a very long time, where judges are given the discretion in a binary sense, which is either release or detain. And release always comes with conditions. Now, the parameters of that will be determined, and I'm sure there will be appeals. And so, I'm not going to give an opinion on whether or not I think any of those have merit. But what I will say is that we are working very hard to implement the new processes that are going to come about. There's going to be an increased burden on prosecutors to present petitions and present evidence at a much earlier stage. And pretrial bond services and the probation departments around the state are going to have much higher burdens in much shorter time frames than they did before. So we are all working very hard to work within those parameters and work with the new law. But I would caution anybody to do the research on what the law actually says versus the scaremongering that's going on around it. And I would disavow any group that is not sticking to the facts about what this is. With that, I will say that when I appear in bond court, the last thing we want to do is endanger public safety. I think judges still have the discretion to make sure that that doesn't happen.
Thank you. Chris Kennedy, how do we reduce the lengthy delay in court proceedings that lead to multi-year affairs?
Yeah, so that was an eye-opener when I left the state's attorney's office. Prosecutions are generally pretty quick. You have a Speedy Trial Act. Somebody's out on release, you have 160 days, they're in custody, 120. You got to try the case fairly quickly, although the defense often wants continuance, and so that extends those time frames. But then I went to a civil case that it had been going on for years before I got into it, and I spent 2 years working on it. It was a massive case, $10 million at stake, and sometimes these cases take a lot of time to develop. And that is not to say that we can't increase efficiency. One of the things that I think we've done a pretty good job with since COVID is increasing procedural inefficiencies that we used to have. As a practitioner, I would drive an hour to go to court to appear in front of a judge for 5 minutes. Now, people can pop on Zoom for the routine matters, and it's much more efficient for practitioners. Now, I think judges have a responsibility to make sure that justice is delivered promptly. There are incentives to delaying cases for one side or another, and so that can be unfair to the other side, and judges have to make sure that the playing field is even. And like I said, with the consideration that things do take time, we still need to increase the speediness of our determinations. And I think we've been doing a pretty good job of that in Lake County. So.
Thank you. Susan Clancy Boyles, same question.
You know, it's interesting because having served in so many different courtrooms and presiding over so many different types of law, you have a juvenile case or an abuse and neglect case where you have a family or a child that is in need of permanency, in need of safety. That's something that needs to move quickly. The Illinois Supreme Court has just come out with policy standards and time standards for each and every case. So judges now have a commitment and somewhat of a time standard that they can refer to in their own courtrooms of where how long these cases should be taking. Juvenile, like I said, needs to move quickly. Felonies, as Judge Kennedy said, they tend to move much quicker than some of the civil cases. Right now, I sit on cases, death cases, that last years because they involve numerous doctors, numerous experts. And you can't push a case that will compromise someone's right to be in court and have their case heard and fully developed. So it's going to be a balancing factor. But we now have the time standards set forth by the Supreme Court to use as a guide, and so the judges can then be able to both push attorneys a little bit harder while still maintaining fairness and everybody getting their day in court.
Susan Clancy Boyles, what is your view of stare decisis? How important is it to recognize case law?
It's important. The worst thing that you can have is a judge who is going to legislate from the bench. A judge needs to be guided by statute and by precedent, prior case law, how it's been interpreted. That's the judge's role. The judge's role is not to come in and, in essence, create new law. We're not in the legislative branch. We're a separate branch. So our role is to enforce and to follow the law as has been previously decided. And that's where the appellate court comes into play, because once they make a decision, unless it goes up to the Supreme Court, that is the final rule of law on a particular issue that we need to follow. So that it's very important.
Thank you. Chris Kennedy, same question.
Stare decisis is the notion that what has been decided stands. And we have all become aware of that in recent years because of the U.S. Supreme Court and various decisions there. And the notion is, and it's a doctrine, it's really a means of interpretation. It gives respect for what has already been decided. And so we, as a functioning society, can't have laws change or decisions of courts on laws and constitutional issues in particular change based on the makeup or the identity of a given judge or a panel of judges. And so I think it is incredibly important that we respect what has been decided. And that is the difference between trial courts and appellate courts. The appellate courts have precedential ability to set precedent in their decision-making that has to be followed by lower courts. By the same token, we have to follow the higher courts. So the state Supreme Court and the U.S. Supreme Court will make certain decisions that we'll be bound to. And so it is one of many doctrines that appellate courts especially are bound to, and I have a great deal of respect for the rule and its role in our democracy, that we can count on rights that we have previously had and been able to count on, that the law is not simply going to be reversed just because it's a different judge or panel of judges than there were before.
Thank you. Chris Kennedy, what are the effects of undisclosed and outside contributions on judicial elections? And what impact will the new Judicial Campaign Finance Rule, HB 716, have?
I think HB 716 bars out-of-state money, is that the provision? Either way, it means my brother, I can't ask him to donate money, but my brother in New York, he's not going to donate money anyway. But the money in politics generally can be pernicious if you don't know where it's coming from. And that we've seen permeate into the judicial sphere. It's been going on for a very long time. And at our level, I think part of my race, the biggest challenge has been just getting attention. You know, we're at the bottom of the ballot. Many people, voters, don't know what the appellate court does. And so education is a big part of it. Now, we are not likely to have dark money or the millions of dollars in negative ads coming into this campaign. This is more grassroots and lower level. And but it is certainly an influence on decision-making in courts around the country that we've seen, where someone on a court makes a decision and then one group or another comes after them, sometimes without identifying who they are. And that is very troubling for a healthy, functioning democracy, to have judges subjected to the political winds. We're the independent branch. We're supposed to be insulated from that type of thing. So I think it would be a positive development if we were to have perhaps more public funding of these types of races without the need for that type of fundraising.
Thank you. Susan Clancy Bowles, same question.
The most important thing to any judge or the judicial branch in general is independence. And it's difficult for a judge being a candidate because of the funding factor and the financial factor. I think in a perfect world, if we could all agree that every judge, regardless of what race, would be given a certain number of dollars publicly, and that's all that they had, and everybody was running from a similar playing field, we'd all be better off. In a perfect world, if there were no finances involved with it, so because it needs to be based on experience. It needs to be based on the fundamentals of doing the job, and not on how much money you have, how many signs you have, anything else. So to maintain that independence, I would love to see a blanket rule that applies to all judicial candidates, and everybody's operating with the same amount of funding, and just going literally so people are focusing on the right things, the experience of the individuals.
Candidate Clancy Bowles, how should appellate court justices be approved? Partisan elections, nonpartisan elections, or appointed? Why, if appointed, who should appoint them?
Well, right now, there are some appellate court justices that are appointed. Kane County does not have an elected appellate court justice sitting on the 2nd District. We have an appointed circuit court judge that is sitting there by assignment. So that is appointed by the Supreme Court. I do think that they should be elected in nonpartisan elections. Judicial races should be nonpartisan. If we are doing our job, politics has no basis in it, and it does not come into play. So nonpartisan elections, elected positions, so people cannot be removed at the whim of a Supreme Court justice, 100%.
Thank you. Chris Kennedy, your response.
The Illinois Constitution calls for a dual system in which there are appointments and elections. All right, so the Supreme Court is elected, and very often that is based on who left the last position will appoint somebody to run, and then they run as an incumbent, which is an electoral advantage. This is the first time that I'm aware of where there's an open seat, both at the Supreme Court and the appellate court level, where somebody was not appointed. All right, and that means that for the first time, potentially ever, we're actually having open elections without an incumbent in place, and that's important because it is a rarity. And there is a lot of talk about how there should be, strictly merit-based selection, and merit is in the eye of the beholder. And very often, if you look at the county breakdowns, if you're not in the majority party of a county, you're not likely to be appointed as an associate justice, or a judge, and you're not likely to win an election for a circuit judge. And so you do see politics permeate the selection process, whether it's open politics or behind closed doors. And so I think we all need to be aware of that. And this is an opportunity for us to have an open airing to the extent that people will get our messages, and people watching here will help spread the word, hopefully, that we have an opportunity to actually make a difference in the courts for a long time to come. So.
Candidate Kennedy, how long should appellate justices serve?
Well, under the Constitution, it's a 10-year term, and at the end of that 10 years, you run for retention. You're not running against somebody else, but you do need to get 60% of the electorate. And it's very rare that someone is not retained. The discussion about dark money earlier, that was a major factor in Justice Kilbride not being retained a couple of years ago, which actually led to the redistricting based on population. Now this second district is 5 counties of 1.7 million people instead of 13 counties. And so, like I said, it is now open for the first time ever. And my colleague Liz Rochford is our candidate for Supreme Court. She is highly, highly qualified and deserves your vote. But I think I do too. And I will happily leave you my web address and Facebook page later so you can learn more information about me. Thank you.
Thank you. Candidate Clancy Bowles.
I think one of the important things, and one of the reasons why I think I'm the right candidate for this open position, is because I'm a boots-on-the-ground judge. I've been a trial judge again in my 16th year, so I have served in every capacity. To be able to now go to the appellate court and review those decisions that are made at the trial court level can only happen if you've served as a trial court judge, as the training for this. This is both pre and post-COVID. There are some appellate court justices that have not been in a courtroom in 20 years, especially now post-COVID. Things have changed. How we're doing justice on a daily basis has changed. So I do think it's important to be able to have somebody who has boots on the ground and the knowledge of what's happening now and how justice technologically is being delivered, and some of the issues that we're having with the pro se's and how that affects the decisions. So really important. I'm in support of the 10 years right now with the retention vote, but I do think that to have limited terms beyond that, so we have people that know what's happening daily in the courtrooms, is important in making the appropriate decisions.
Candidate Clancy Bowles, if case law was based on biases regarding racism or gender, should it be honored today?
Well, that's a hard question for me to answer because I don't know how you go back, how somebody's going to say what the decision was based upon. So again, if we're talking about specific rules or things like that, the answer to that would be I have to follow the law as written now. And that's my job. And if I'm assessing every rule or statute at what period of time it went into effect, then again, I'm inserting my own opinions as to what the written law is at this point. So that's not my job. That's the legislature's job. And my job is simply to follow the law.
Candidate Kennedy.
Well, the simple answer is no. I mean, there are many overtly racist cases in American history, and many of them have been reversed. Some are still on the books. Many of those are just simply not followed. Maybe there hasn't been a case appropriate to overturn them. But we ought to be cognizant that there is certainly a history in this country and in various places where you still see the effects. And so it depends how a case comes up, whether it is appropriate to overturn a prior decision. But the Supreme Court has made some efforts in recent years, and I know some of the justices want to go back on a couple of additional cases to reverse them. But we need to be cognizant that there are inherent adverse effects of history and of historical decisions by courts, and we can't ignore that effect. That doesn't give us fiat to go and fix the world. We have to deal with the cases before us and the law that's established by higher courts. But nonetheless, we can certainly be a voice for what is right in determining the effects of laws. And so I think we all have to be honest about that history and cognizant of its effects on people.
Thank you. Our time is up for this forum. So let's go to our closing statements. And Chris Kennedy, would you please start?
All right, thank you. I really appreciate you doing this. Our biggest challenge, like I said, is just getting information out to voters. I am going to be the very last person on most of the ballots, unless there's a sub-circuit race out there. Most of those are not competitive or even contested at all. This race might be the last one that's contested on the ballot, and it's a very long ballot. And so getting awareness out there is a major factor. So I want everybody to please look at our records, look at my record, and consider all of that experience and background and perspective that I think we need a difference on the appellate court. It's never elected a Democrat before in its history from the 2nd District. And there are a limited number of justices proportionate to the population of the counties. Lake County is almost half the vote. Certainly doesn't have even a quarter of the justices on this district. So what I tell people is help us get the word out, give them directions on how to fill out their ballot as if you were giving them directions to the airport that they should keep going until they get to the Kennedy. So I appreciate the opportunity to speak before you, and I wish you all well. Thank you.
And Susan Clancy Bowles, your
So-
closing statement.
So the appellate court, again, the importance of the appellate court is the reviewing court of every decisions that made at the trial court level. And since the Supreme Court accepts so few cases on appeal, the appellate court really is the court that makes the rule of law that we as citizens live under on a daily basis. So experience is key. Experience is key. My 17-plus years as a practicing attorney were great experience, as I indicated, to come on the bench and be an associate judge and be in traffic court. Since then, I've been in every other courtroom, practicing every other type of law, doing exactly what I would be reviewing at this next level. My experience has prepared me and trained me to be on the appellate court. I urge you to look at that. Again, first woman from Kane County to serve on the appellate court, let alone elected. We're a smaller county compared to Lake. And so we need a seat at the table. We need a seat that can't be removed. And so I encourage you to support my candidacy. Please take a look at my literature and everything I've done both in the courtroom and for the community. Again, we can't thank you enough, I think both of us, for being here and being interested in these races. I call us the librarians of the election cycle because we're not crazy exciting, but it's important. So we thank you for being here and your interest.
Thank you very much. We appreciate your attendance, both of you candidates. I'd like to take the opportunity at this point in time to introduce Michael Childress from the DuPage NAACP. If you would come forward a minute and give us a little bit of information about your organization. And thank you for participating with us.
Thank you so
Appreciate it.
much. First of all, I want to thank the candidates for being here, and I want to thank the League of Women Voters for partnering with us to hold these forums. I can remember when I first was a neophyte trying to get into the political arena, I remember going to vote, and you get to what they would call the end of the ballot, and there'd be some names, and we have no clue who these people are or what they're about. And the NAACP, as well as the League of Women Voters, have made a concerted effort to make sure that we are into the three-legged stool, as I like to call it. We registration, mobilization, and education. And today is the day for the education. We want to make sure that we hear from these candidates. We want to make sure that we want to understand their positions so that when we walk into that voting booth, we're an educated voter. We're not just walking away saying, well, I don't know who the people are, we're not going to vote. Because as you heard today, these positions are extremely, extremely important. They determine more about how we live than the guys who sit in Washington. We need our local judges to be in tune with the lifestyles that we have and be, really, really sympathetic to the communities and what we're facing. Again, I'm really proud to be here. I really love being with the League of Women Voters. We have had some great partnerships, so much so that I'm a member myself. My league is Roselle and Bloomingdale, but I'm always, whenever the League of Women Voters call me and ask me to do anything, they got an ally in the NAACP. So thank you.
Thank you. Thank you very much, Mr. Childress, and we are happy to partner with the DuPage NAACP as well. I want to thank you all for attending the forum. I want to also tell you that the next forum is scheduled for Wednesday, September 21st at Aurora University's Crimi Auditorium. That forum will include the candidates for the Illinois Senate 42nd District and the Illinois House 83rd District. That event begins at 7 o'clock. Additionally, we will be hosting a forum on September 27th at the Geneva Library beginning at 6:30. Those who have been invited are the candidates for the offices of Kane County Board Districts 10, 11, 12, 13, 15, and 18, Kane County Sheriff, Kane County Clerk, and Kane County Treasurer. As I previously indicated, we have scheduled a final forum for October 4th at the Geneva Library. All candidates who are invited must respond by signing the participation agreement, and in order to be afforded the opportunity to participate, both candidates for an office must be present and have signed the agreement. We have an empty chair policy that prohibits only one candidate participating. So I want to thank candidates Susan Clancy Bowles and candidate Chris Kennedy, both running for appellate judge in the 2nd District, for participating. And thank you, BATV, for Audrey, for taping and live streaming for us. And thank you to all of the league members for participating. Thank you.